The petitioner is Christian by religion and the respondent is Hindu. There was a son born from the marriage. 2018 they separated. I must bring to your lordship's notice that subsequently she has remarried.
You don't have a valid divorce,
Yes.
and you marry for the second time. How would that be a valid marriage?
There is a son from the marriage. She has relocated to Delhi. The son is staying with her in Delhi. Everything is fine, my lord. The dispute has arisen because the custody was to be with the father. Though in effect the custody has been with the mother throughout. Now, because she has moved to Delhi and the son is living with her in Delhi, the father wants the child to be brought back to Bangalore and he wants to enforce the decree. Petitioner.
Yes.
But the petition challenges the order of the family court refusing to stay a decree of mutual consent passed by the court, my lord, insofar as the parties are concerned. The petitioner is Christian by religion and the respondent is Hindu. But they were married on 24th of February 2010 in accordance with Hindu rites. Thereafter, the marriage, my lord, was not registered under the provisions, not solemnized under the Special Marriages Act, nor was there a church wedding. No, there was a son born from the marriage. 2018 they separated, and in 2021, my lord, they filed a petition for divorce by consent under the provisions of the Special Marriages Act. Though the marriage has not been solemnized under Special Marriages Act, the only document produced before the family court at the time of presenting the petition for divorce was a certificate of registration under the Haryana Compulsory Registration of Marriages Act. All states now have most states have this Registration of Marriages Act. Under that act, that unfortunately, my lord, the family court has not perused that, and yes, by consent we obtained a decree of divorce. Thereafter, my lord, there were certain developments that have taken place because of which the petitioner wanted to seek modification of the decree. At that time, my lord, she was advised in July of this year that the marriage itself is invalid. So there's no question, when the decree is invalid, there's no question of modifying the decree. No, this law is well settled, my lord, by the Honorable Supreme Court that any decree or any marriage between a Hindu and a Christian under the Hindu law.
No, but that cannot be used by the wife for her own convenience. Someday when it was happy with her, she will take a mutual consent divorce.
She was unaware, my lord, of the. In fact,
ultimately, under whatever provision it is taken, the intention of the parties is to put an end to the issue.
Correct.
And to get the benefit out of it. You got the benefit out of it. Now you wanted it, now you want for some reason to suit your convenience, you want it to be amended. Now you understood that law doesn't permit.
No. In fact, she wanted amendment of the decree. The advice she has received is that since the decree itself is invalid, there is no question of the decree getting amended because the marriage itself is invalid. This law is very well settled.
No, law is settled.
Yes.
That is no. What is the intention of the parties?
No, what has happened is this. No, I must bring to your lordship's notice that subsequently she has remarried. Her relationship with the person where the marriage took place earlier also is cordial. There is a son from the marriage. She has relocated to Delhi. The son is staying with her in Delhi. Everything is fine, my lord. The dispute has arisen because in terms of the mutual consent decree, the custody was to be with the father, though in effect the custody has been with the mother throughout. Now, because she has moved to Delhi and the son is living with her in Delhi, the father wants the child to be brought back to Bangalore and he wants to enforce the decree. This is purely a technical aspect. If there was a possibility of seeking modification, we would have availed that opportunity. Unfortunately, there is no possibility of modifying the decree, considering the decree itself is invalid. The Honorable Supreme Court says, by consent, parties cannot confer jurisdiction.
That's the law.
Otherwise, there is no intent not to.
No, because that is advantageous for her now. Because now she wants to get out of that particular clause, and she wants to have the custody of the child.
Custody has been with her throughout.
No, whatever, but that is contrary to the terms of the decree.
Correct. Notwithstanding the terms of the decree, custody has been with her throughout. The difficulty is this: I cannot seek modification because the decree is invalid.
So you will seek for ways and means. How do you get out of it? It has come now. The legal advice is.
The only other way I can do is to challenge the decree, and thereafter file a petition for custody of the child. It will be a child out of wedlock, not from the wedlock. That unfortunately that is the situation we are faced with.
Notice the response.
That is what the family court has done. Notice the order challenged before your lordship.
Did we know, when was the compromise decree?
Sorry, my lord.
When was the compromise
In
decree?
2021, my lord, on,
2021,
Yes.
something is going on till 2025.
Yes.
So why should we interfere with that now?
no, she was absolutely unaware that the decree itself is not valid.
What is the, no, if it is not stayed, what will happen?
But the father wants to enforce the decree, which is not a valid decree. I will be open to.
No, through that decree, what all you could get, you can have a marriage. Now your marriage is an invalid marriage. No?
It's a legal conundrum, my lord. We are
It has
faced with
to
a
follow. Now,
situation.
if we suspend this, now your marriage becomes an invalid marriage.
No, that marriage is invalid.
But-
My first marriage
No,
itself is invalid.
if you don't have a valid divorce.
Yes.
And you marry for the second time, how would that will be a valid marriage?
Look, this my marriage to the respondent here itself is void. It is not recognized by law. That is the law, my lord, laid down by the Honorable Supreme Court. My lord,
Unless
we are
and
not,
until it is declared.
my lord, we are not fighting shy of, my lord, seeking modification.
But what I feel is court ordering notice was the right step. There can't be a stay.
The reason court orders notice is to verify whether they were not aware about Special Marriages Act.
It's not that. Let them come, let both of you contest. You have mutually taken a divorce.
True, my lord.
No, mutually appearing before the court, you can, that can be heard. No
Sir,
stay.
may I make this request, my lord? My lord, let notice be issued in this matter. Because date given now is 25th of September, 2 months later.
Because you know, the hurry of the parties is not the concern of the court.
Child,
Things have to. It's okay. 21st, from 21, this is happening. Now we are in 25, and September, giving the date, it's September is not wrong. How can the court decide?
But when I'm seeking an injunction, my lord,
Injunction of,
the application, I'm seeking the suit for declaration with an interim application to stay the decree is what I have sought, my lord.
if the court decided, I'm
But
not.
may I make this request, my lord? If your lordship permits me to serve the notice on the other side,
Because why should we? The court will decide.
No,
Let
the
the trial
law-
court decide in September, what happens?
my lord, the child's school admission is not done. The child doesn't want to come. Your lordship wants to interact with the child, my lord. We'll very well bring the child before your lordship. He's 11-year-old boy.
Because every matter can't be done by the court immediately.
I understand. My lord,
Lot of work for them.
No, but when the law,
And that too, a kind, in one of this nature.
Yes.
Where you're having, like, you know, you had your own fruits of enjoying the fruits of the decree
No,
from the last 21 to 25.
the relationship between the petitioner and the respondent remain cordial to date. It is not that we are fighting. We converse with each other on a daily basis. But we are faced with a situation, I am faced with a situation where I am not in a position to seek modification. Your lordship may kindly appreciate my
I
difficulty.
can understand, but I'm saying no, there is something that has to be interfered by this court from according to you, the trial court has not interfered. It has not interfered because the other side should come.
For the only reason I want to find out from him whether he was aware or not. I've gone on affidavit and stated, I am Christian, he is Hindu. That is indisputable. We have stated that, I have stated that,
You can add interim injunction.
sorry, my lord,
You're seeking an ad interim injunction.
of stay of the decree is what I'm seeking.
Ultimately, that's
Yes,
what it is, without
true.
notice to the party.
True.
So because something what is there in existence from 25, suddenly why should we interfere with it in
No,
in
when-
21 to 25?
No, when the court, my lord, is made aware of a fact that a decree is invalid, is non-est, because the party's marriage itself was invalid.
That can be done, that can be slowly, we can take it forward.
But the difficulty is that the child's future is now, my lord, in jeopardy.
Mother
Because of the
understood it
situation.
after 5 years.
Sorry, my lord.
Mother understood it after 5 years.
No, because we were absolutely fine. I had not moved to Delhi. And, my lord, I had agreed to the child studying in Bangalore while I was living in Delhi. The child is refusing to come.
Then why did she agree for such a clause?
She was, my lord, at that point in time, my lord, they were staying in the same apartment. I've said it we were staying in the same apartment complex. Custody was virtually with me. He was only meeting the father for 1 day in a week.
So then
We
why
have
did-
enough correspondence.
Consciously, mother incorporated, accepted for such a clause where custody should be given to the father, and she didn't give it.
कई मामलों में अंतर धार्मिक विवाह करने के क्या परिणाम हो सकते हैं, इस पर अपनी राय कमेंट्स में जरूर दें। कर्नाटका हाई कोर्ट की सुनवाई में मामला उस बच्चे को लेकर है जो एक अंतर धार्मिक विवाह से जन्मा है, जहां मां चाहती है कि उसका बच्चा उसके साथ दिल्ली में रहे और पिता चाहते हैं कि वह बैंगलोर में रहे। पत्नी के वकील ने बताया कि पत्नी क्रिश्चियन है और पति हिंदू और इनकी शादी हिंदी रीति रिवाजों से हुई थी। कुछ समय बाद साल 2018 में उन्होंने अलग होने का फैसला लिया। पति ने दूसरा विवाह कर लिया क्योंकि उसके अनुसार पहली शादी कानून बाध्यकारी नहीं थी। इस पर माननीय न्यायाधीश ने सवाल किया कि फिर उसका दूसरा विवाह कैसे वैध है। आगे वकील ने कहा कि बेटा बैंगलोर नहीं जाना चाहता और यदि अदालत चाहे तो उससे व्यक्तिगत रूप से पूछ सकती है। यहाँ असली मुद्दा बच्चे का भविष्य है, क्योंकि इन कानूनी कार्यवाही के चलते उसका एडमिशन अभी तक लंबित है। फिलहाल के लिए बस इतना ही। इस मामले की अगली अपडेट जल्द लेकर आएंगे। धन्यवाद।